Respondent in the appeals Futter and Pitt against the Commissioners for Her Majesty's Revenue Trustees.
Trustees and others who have fiduciary powers to exercise must take their decision-making seriously. They must take relevant matters into account and disregard irrelevant matters. If they fail in this duty, the court may intervene and set aside their decision. Tax is an inescapable fact of modern life, and it's a relevant matter for trustees to take into account. During the last decade, there have been several cases in which tax planning arrangements involving trusts have gone wrong, and the court has been asked to set them aside under what has come to be called the rule in re Hastings Bass. Until recently, the Revenue declined to take part in such cases. But in these two appeals, the Revenue have taken part and have argued that the rule is limited in its scope. The Revenue succeeded in the Court of Appeal, and the issue now comes before the Supreme Court for the first time. The appellant in one appeal is Mr. Futter, as one of the trustees of two family settlements which he set up in 1985. Until 2004, they had trustees resident in Jersey. Under the capital gains tax legislation then in force, beneficiaries who received distributions of capital were charged on stockpiled gains realised by the Jersey trustees. Mr. Futter and his co-trustees were advised, incorrectly, that these gains could be offset against the beneficiary's own allowable losses or annual exemptions. Relying on that advice, they made distributions of capital to Mr. Futter and his children in 2008. Mr. Futter brought proceedings seeking relief under the Hastings Bass rule. The other appellant is Mrs. Pitt, who had fiduciary powers as Mental Health Act receiver for her husband. He had been incapacitated in a road accident and received substantial compensation under a structured settlement. As her husband's receiver, Mrs. Pitt took professional advice about putting the compensation into a discretionary settlement for his benefit. The advice failed to warn her that the discretionary settlement would attract an immediate liability to inheritance tax and further liabilities later, unless it complied with certain requirements. These could easily have been met, but they were not met because of inadequate advice. After her husband's death, Mrs. Pitt brought proceedings seeking relief under the Hastings Bass rule, or alternatively, under the equitable jurisdiction to set aside a voluntary disposition on ground of mistake. It was not in dispute that Mr. Futter and his co-trustee and Mrs. Pitt acted reasonably in reliance on what they supposed to be competent professional advice. That is the principal ground on which the Court of Appeal allowed the Revenue's appeal from the first instance decisions applying the Hastings Bass rule. The Futter trustees as a body and Mrs. Pitt as receiver did their best to take account of tax as a relevant consideration. It was not their fault that the advice was inadequate. The court can intervene only if trustees have been in breach of their duty. Otherwise, persons who are beneficiaries under a trust would be in an unduly favoured position as against other taxpayers, and there would be constant uncertainty about the finality of trustees' decisions. The Court of Appeal also dismissed Mrs. Pitt's claim based on mistake. It held that rescission could only be granted if there was a serious mistake as to the effect of a transaction, that is, the nature of the transaction, rather than its consequences. The Court of Appeal held that a mistake as to tax consequences, however serious, was not sufficient. In a judgment given by Lord Walker, with which all other members of the court agree, the Supreme Court upholds the decision of the Court of Appeal as to the Hastings Bass rule. There is an important distinction between trustees acting outside the scope of their powers and acting within the scope of their powers, but with inadequate deliberation. If they act outside their powers, they will not automatically be protected by having taken professional advice. But if they act within their powers and take what appears to be competent professional advice on matters which call for such advice, they will not be in breach of their duty. The Supreme Court does, however, allow Mrs. Pitt's appeal on the ground of mistake. She had, as the Court of Appeal found, a conscious belief that the proposed discretionary settlement would have no adverse tax consequences. In fact, if not set aside, it had very serious tax consequences. the total liability being estimated at between £200,000 and £300,000. This liability could have been avoided very simply and entirely properly by complying with the statutory requirements. The Court of Appeal was wrong to refuse rescission on the ground that the mistake, though serious, was only as to tax consequences. The Supreme Court reaffirms the test, approved by the House of Lords in the old case of Ogilvy and Allen, that the jurisdiction requires a causative mistake of sufficient gravity that it would, in all the circumstances, be unjust not to set aside the disposition in question. Mr. Futter's appeal is therefore dismissed, and Mrs. Pitt's appeal is allowed.